Welcome to Brief Encounters. This is Meridel Bulle-Vu from Legal Aid DC, where I'm a supervising attorney in our domestic violence and family law practice. I'm joined today by Councilmember Brianne Nadeau, who represents Ward 1 on the DC Council and has since 2015. Thank you for joining me today.
I'm glad to be here. Thank you.
So last session, Councilmember Nadeau, you introduced and shepherded through legislation that amended DC's divorce laws, specifically to remove the waiting periods to file for divorce in DC, to require judges to consider the history of domestic violence when awarding alimony and dividing marital assets, and to explicitly authorize judges to award exclusive use and possession of a marital home during the pendency of a case. I wanted to talk with you today about those legislative changes, which I'm very, very excited to say are now the law in DC.
Yeah, it is exciting. And we worked for it for a long time. So I'm really glad that it finally came together in the end.
Can you share what prompted you to originally introduce this legislation?
A constituent came to me, and her name is Elaine, and she is a survivor of domestic violence. And when it came time for her to leave her partner, she found herself bound to him by the law. And I really wanted to do something to change that so that people who are trying to get out of a dangerous situation don't have to lose everything and don't have to stay tied to that person any longer than necessary.
We at Legal Aid DC in our roles as domestic violence advocates have certainly long witnessed situations like the one Elaine faced. We've seen the deleterious effects of the separation requirement that it had on survivors of domestic violence, forcing them to remain legally tied to their abuser for up to a year after deciding they wanted to end a marriage. And in some cases, probably some of the cases we didn't see, preventing them from leaving, right? Where they ultimately perhaps stayed in a dangerous situation in a marriage because they felt they had no choice and nowhere to go for that year to be separated. There was considerable testimony, including from Legal Aid DC and other DV advocates, about the originally proposed Elaine's Law. Was there a story or some testimony that had a meaningful impact on you and perhaps affected your decision to reintroduce the amended legislation last year?
I think for me, it was that persistence of the community around this issue because, there's hundreds of laws introduced every year. And whether or not they move forward has so much to do with whether the public's engaged and whether the public cares about the future of that legislation. And this was one where there were so many people advocating to get it done because we all knew that it would have an impact on people's lives immediately. Whether we realize it or not, we all know somebody impacted by domestic violence, possibly someone close to us that we don't even realize. And that makes the stories behind the bill all the more compelling because they're so close to home.
One thing that stuck with me from that first hearing was just the near unanimous the near unanimous vocalization of the desire to just end the divorce waiting period. That, like, whatever the other provisions were, and whatever other creative ways we could try to get to a more just resolution for someone like Elaine, that really stuck with me, that the domestic violence advocates and the public witnesses just talked about how horrible, like you said, it was to be bound, legally bound to someone for longer than they wanted to be. So I really appreciate that that is one of the pieces that you brought to the new bill and reintroduced in a way that makes it as accessible as possible. Because instead of just limiting that relief of no waiting period to just survivors, I think we really appreciate that you just got rid of it for everyone, survivor or not, anyone. All of these adults who are in marriages can decide that they no longer want to be married and leave that marriage immediately.
That piece of it really stood out to me as well in that first hearing because, when you hear consensus around one thing, that's rare typically in these conversations. And I think you hit the nail on the head with that. I mean, people who don't want to be married shouldn't have to stay married, period. We shouldn't have to give a reason. And consenting adults should have the opportunity to decide how and when their marriage ends.
Agreed. And previously, the ability of one spouse to prolong the marriage by withholding consent really gave abusers another lever of control. Like, we very often see abusers use the law and judicial system against survivors, as happened in Elaine's case, when they no longer can continue their pattern of physical abuse or emotional abuse directly against their spouse. Is that something that you heard from your constituents as well?
It is. And interestingly enough, there's actually something in the Jewish community also with a marriage called a get, which is where the rabbis actually have to consent for the divorce officially. And it is something that sort of in the parallel, like in the civil world, is something that is used in the same way and something that had actually been lifted up to me even before I was council member and doing this work when I worked in the Jewish community. And so when I came into this role, and saw how it was happening in our public law, it's just another version of the same thing where an abuser can hold power over somebody more vulnerable than them. And in this case, their spouse and perhaps their children, right? And anytime we can eliminate that lever and eliminate that binding, we're going to make it easier and safer for people to get out of those situations.
I just want to reiterate how much we appreciate your knowledge of this area and your support for the many DC residents from all walks of life who are going through something like this. It's really so impactful to have someone in a position of power who gets it. So thank you for that. One of the other provisions in the law that passed relates to alimony and the division of marital property. I know some people said, like, oh, well, we don't need to add something about domestic violence because the court can already look at why a marriage broke down. Can you just share why you thought it was important to explicitly require the courts to look at the history of domestic violence?
This was actually kind of at the heart of the original bill, too, even though it sort of ended up in a different format, because courts often have the ability to do things. That doesn't mean that they do, right? And when you put special emphasis on it in the law, that's signaling to a judge that it's something the legislative body and the government believes should have a high priority. And in the cases that we heard from and with Elaine, there's a situation where you might end up, after having survived abuse, still suffering financially because of an unfair judgment or because that abuse wasn't taken into consideration. This is an opportunity for someone to be made at least financially whole, if not completely whole, right? There's a lot of work that has to be done after the fact, but giving people a strong start. And we know that oftentimes finances are the reason people are afraid to leave. So this is also a signal to people who are being abused that we will look out for you as a government. We will give you a fighting chance to have what you deserve financially so you could start a new life.
I appreciate how those first two provisions work in tandem because, previously, if you didn't even have access to the divorce process for a year, you couldn't even file, then you didn't have access to interim relief. You couldn't get financial relief. And so somehow as a survivor, you had to figure out how to live separate and apart and somehow support yourself for a year before you could even get to the court and say, hey, I need temporary alimony.
Kind of crazy if you think about it, that that's how our system was until very recently.
It really, really is. It feels so archaic. And it left so many survivors in a really precarious position, unable to move on or support themselves or their children. We really appreciate the approach you took in this version that did become law, that creates a bit of a balancing act. Because, like we were talking about before, where abusers really will use the law against the survivor in any way they can, when there's a black line approach, that can create an opportunity for abuse there. And so we are very hopeful that the spotlight that you put on to signal to the courts, this is important, please pay attention to it without creating a black line rule, will hopefully protect as many people as possible and not put them at risk of having those laws used against them.
That's right.
So after the public testimony regarding this bill, the council opted to broaden the categories of domestic violence that the court should consider beyond just intrafamily offenses. The language in the law now requires the court, when considering the circumstances that led to the estrangement of the parties, to look at, and I quote, the history of physical, emotional, or financial abuse by one spouse against the other. Can you share why you supported this broader definition of domestic violence?
Sure. I mean, legislating is sort of an iterative process. And for me, I take my cues from the people that are doing the work. And in this case, we heard at the hearing and throughout the period leading up to the markup that this would actually better serve our community of survivors here in the District of Columbia. I'm always willing to make changes and get the bill closer to the larger intent before we pass it so we don't have any unintended consequences, but also so that it can be the best possible version. And as much as I try always to get input before we introduce legislation, there's always more along the way. And oftentimes we introduce an imperfect version so that we can get the ball rolling and then we can make tweaks before it passes into law.
Well, thank you for listening to survivors. And, we unequivocally believe that they know what is best for them, and love that you do too. We agree that requiring a finding of an intrafamily offense, which our audience is a crime by one spouse against the other, ignores the emotional and financial abuse that often can define a controlling relationship and can really be a precursor to physical abuse. So, by taking the broader approach, I think you've really made it so that survivors can get out of a bad marriage, hopefully before things escalate.
That's the goal.
Yeah, that's the goal. So another less talked about provision in the new law explicitly authorizes judges to award exclusive use and possession of a marital home during the pendency of a divorce proceeding, irrespective of which party has a property interest in the home. This is relief that is commonly granted in civil protection orders, sometimes colloquially referred to as stay away orders, but that in our experience, divorce judges were really hesitant to grant, even when they were making decisions about temporary custody. Can you talk about why it was important to include this explicit authorization in the law?
I think you got at this a little bit earlier when you were talking about how hard it is, while you're trying to separate to then find a home and set yourself up and be financially stable while you're going through this divorce. You know, Even though we eliminated the waiting period, the housing piece is still a huge wild card. And women, especially, leaving oftentimes don't have somewhere safe to go, don't have somewhere stable to go, can't find housing they can afford, if they haven't been the breadwinner, especially. And so this is about ensuring that people surviving violence don't end up homeless, don't end up staying because they can't find a place to keep their kids safe. Really about ensuring the best possible safety net for people and really just setting the course, right? So that, hopefully ultimately they end up with stable housing when the entire procedure is over and all is said and done as well.
Anecdotally, I can share that housing is one of, if not the biggest concern for our clients who are survivors. And under the previous law, it was not uncommon to see survivors making really heart wrenching choices. Do I stay in this marriage with my family, or do I leave, even if it means leaving my kids behind? Because, like you said, you might have nowhere to take them and not want them in the shelter.
It's an impossible choice. I mean, as a parent, the idea of leaving my kids behind, I would just never do it, right? I mean, it's an impossible choice.
Think about how bad it would have to be
I can't.
before you did it, right? And then, we have litigated some of those cases where it took years for the divorce and then the custody proceedings to be finalized to get the kids back with the survivor.
And then you're putting your custody at risk because you've, in the eyes of the court, abandoned your kids, right? I mean, the whole thing is just this, in my mind, is a lifeline.
Well, I agree. And as a common sense matter, I think that if a judge is deciding which parent should have custody of children during the pendency of the proceeding, they should, of course, also be able to award exclusive use and possession with that. So to decide you can be in the home and you can be in the home safely without the other parent having the right to come in and disturb the peace or to come near you. That, again, like I said in the question, this is relief that the court routinely orders in civil protection orders. But we see these legislative changes as a way of opening up options for survivors moving towards safety. Some survivors don't want to pursue a CPO, a civil protection order. It's not the right course of action and relief for everyone. And so we, again, just really appreciate that you and the district are creating options and breaking down barriers to leaving violent situations.
I'm glad that we can work together on it.
Have you heard any feedback from your constituents or other DC residents about how the new law is impacting them?
I haven't gotten to hear the stories yet, but I am really looking forward to it. It hasn't been in place so long, but I'm hoping that, frankly, we just don't hear much, because if people are using it successfully, it should feel like, something easy and clean and helping people move on with their lives and not have to look back.
I can share that the response from our clients and the many people we interact with in family court has been universally positive. There have been so many expressions of relief that somebody can file right away that day. We had the privilege of calling clients who were in the waiting process when the bill passed or took effect in March. And again, just so much relief that they could start this process to get to an end point to be able to really close the door on a bad situation. So I'm very pleased to be able to share that with you. And even some of our former clients who've already been through this process, we spoke to some of them in the aftermath of the bill passing, and they were just so excited about it that their stories, which had been certainly part of the impetus for us, working with you, and it had been part of our advocacy on this, we wanted to let them know how it went. And they were just so relieved that no one else would have to go through really the truly horrible situations that they did, waiting and then not being able to be in the home and not having any financial relief in the interim and having their experiences discounted in the divorce trial. So I'm very optimistic that the goal of all this is at hand.
That was how Elaine felt as well, because by the time we had started working on the bill together, she had already gotten through her divorce and her custody battle and was suggesting this to help other people. And so when it finally passed and became law, she was incredibly excited for others as well.
From our work on the bill, DC seems to be the leader or a leader in eliminating these unnecessary wait times. In fact, I've read that politicians, I think on the extremes in some other states, have even proposed measures to make it harder for one spouse to end a marriage. How do you feel about the fact that we are able to lead the way for survivors and other district residents in walking back paternalistic overreach?
I take pride in being a leader in the country on this. And I think the district tries to lead on sound policy as much as we can. I was going to say we try to lead on progressive policy, but this is just common sense. This should not be a partisan issue. This should just be about two adults, and their relationship, and politicians shouldn't really have an opinion on that. That is unfortunately not the direction our country is going. And even politicians who often say that they don't want the federal government interfering in their business never hesitate to insert themselves into the bedroom and the doctor's office and, matters of marriage. So I think those of us who want to see common sense prevail in our country are going to have to keep fighting for these things.
Well, thank you for all you do to fight for common sense and to fight for survivors. We really just want to thank you for partnering with us and for proposing and championing these changes to make it easier for survivors and really all district residents to access the courts immediately. So thank you for that.
I'm glad to work with you all. Thank you so much for the opportunity to talk about it.